Hello, my true crime lovelies. How are you? It's a good day to have a good day. Even Liberty agrees. All right, Libby. I got makeup on. It's 6 p.m. and not 6 a.m. I did come home early. Sugar Bear is not feeling well, so I picked him up from school early. I got an emergency call. Well, my daughter got an emergency call and she called me. Yeah, if you are adverse to children in videos, please govern yourselves accordingly. Take responsibility for yourselves. But to the rest of y'all, how are you doing? I hope you are as lovely in life as you are in my mind. I do. I'm feeling sassy today. Oh my goodness. I'm sorry, Miss Jackson. I'm sorry, Miss Jackson. Never meant to make your daughter cry. I don't know. I don't know about Miss Sarah. I don't think she can help it. I think she's always throwing shade, even when she's asking for a favor. I mean, everybody is not Brian, girl. Everybody is not Brian. And I feel like Miss Jackson is having none of it. And then she filed a couple of other motions that we're going to go over too. But we'll start with this motion to appear. I guess she's disappeared. No, I kid. I kid. First, we're going to thank the members. I'm going to thank you for being here. I appreciate you. If you like the video, give it a thumbs up. If you want to join the lovely gang, hit that subscribe button. We'd love to have you. And I'll see you on the other side. Here's your intro warning. Da 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 da. Alrighty, let's get right into it. So this was filed today at noon, 8/20, 2025. Respondents motion to appear in person for trial. And then comes the shade. Comes now, pro se respondent Sarah K. Boone, and respectfully moves this honorable court to issue an order for her transport to be rightfully and properly present herself by being included in person for the final hearing in her family law trial on August 25th, 2025. Oh, you caught me. I was doing our show without you. I knew you were going to come in here when you heard me talking. You didn't want to keep laying down? Are you feeling better? Yeah, oh, good. I'm glad to hear that. In support of the respondent's request for equal, full inclusion. Number one, respondent has been ordered by the court without hearing July 28th, 2025 to appear and participate telephonically in this trial due to her incarceration. So much shade. All she had to do was say there was an order on July 28th for telephonic appearance. She put in without hearing, so that's shady boots, right? Shady boots?
Yeah.
Yes. And then, due to her incarceration, there was nothing in the notice that said due to her incarceration. Okay, knock it off. She's incarcerated due to her own actions. Should we put that in every motion, every response? Oh, no, because she'd be mad and she would understand. If it's happening to her, she understands it's shade. She has no problem doing it to everybody else. By appearing via telephone for this vital, life changing trial, the respondent's rights and position are heavily impaired, increasing an unfavorable outcome in her self representation by being excluded in the courtroom with all other parties, and which she is and should be included as such. I think she means of which she is. Like she's a party I don't know all other parties. There's two parties, ma'am. The petitioner and the respondent. How is she impaired? She doesn't specify. And I don't think, I mean, the judge is going to decide based on the facts. So I don't think being in person changes the facts. Now, granted, there is a disadvantage at telephonic because she can't see their reactions. They can't see her reactions, which probably is actually in her favor. We don't have to see her mouth twitching. Nobody has to like see her, doing whatever weird stuff that she likes to do with her face. So she leapt from telephonic though to in person. And she could have settled in the middle and done Zoom, right? Who's paying to transport her from Lowell Annex? Okay, we can't do our show unless the lights are on, right? They can't hear us if we turn off the lights. Okay? Okay, thank you. Who's paying for the transport? Does she really want to go back to Leon County? Because they'd have to keep her there. But we will keep our eye on the jail roster and on the docket. Today's Wednesday for Thursday and Friday to see if they move her, right? They might move her on Saturday. If they do, you will get it here, I promise. Anyway, she doesn't mention the cost. Who's going to pay for her transport, right? The taxpayers. The taxpayers are going to pay for her transport because she refused to sign an agreement, redline an agreement, come to any sort of compromise. Why? Florida taxpayers, rise up.
She's making y'all the oppressed.
Number 3. In-person representation is crucial for the respondent to ensure meaningful access to the court by having the ability to present evidence for her defense, cross-examine witnesses, respond appropriately to arguments made by the petitioner, and accurately perceive the dynamic of the courtroom as a whole. So I would agree with perceiving the dynamic, but again, middle ground is Zoom. The extreme is, hey, don't steal all my drink, is in person, right? Because there's a cost to it. But yeah, having the ability to present evidence, you can do that telephonically or via Zoom. We proved that during COVID. Cross-examine, you can do. Respond appropriately to arguments made by petitioner. You can do.
Because the judge will call on you
and say, Mama, respondent, do you have any response? Or what is your response? Or what say you, Sarah? Number 4. That's a good job. As a self-represented pro se, again, this is shade. Why is pro se a parenthetical?
The judge knows what self-represented means, Sarah.
The respondent is at a significant disadvantage when appearing by phone, especially in a complex trial setting where immediate review and understanding of documents, real-time responses to developments as they arise. So what kind of developments as they arise are you better situated to? Okay. I don't think she realizes she'll be cuffed because there's no jury. It's just the judge. It's a bench trial. So you're going to be cuffed. Your hands are going to be cuffed, which we know you don't like. Your legs are going to be cuffed. Your waist is going to be cuffed. So what sort of immediate review and understanding are you doing? Real-time responses as they arise, because you cannot arise. Communication with the court, presentation of exhibits, observing the opposing party's demeanor is necessary. Now we're going to do 40 chest.
I know the look on Brian's face when he is lying. I need to see his face. Right? I need to see his face. Face needs to be seen.
It is essential for her to engage in all court proceedings for this trial. So that I will give her. That might be difficult because she won't be able to see what they're seeing. But as far as I can tell, she hasn't submitted any exhibits unless they were actually submitted as part of that 33-page rant. I did submit an evidence request to the court to see if I could get the exhibits, but I don't know if they're going to give them to me. It's family court. Number 5, remote participation impedes the respondent's ability to fully advocate for her position and interest, particularly given her documented difficulties in accessing legal materials, submitting and receiving documents from the court, and opposing counsel, and communicating effectively from within the correctional facility. So she's got to leave the facility in order to communicate effectively, which that seems like a stretch. Is she expecting Brian's team to bring copies? Because if she's had difficulty accessing these materials, I don't know how that changes on the day of trial, unless her expectation is that they're going to give her copies, in which it would be fair if their expectation is that she also will exchange copies, which how is she going to do that, right? She put in that one document. She didn't get them because they were $414 or whatever. So you guys let me know what you think.
Because I'm like, what, ma'am?
Number 6, the respondent's physical presence and participation greatly minimizes the risk of technical difficulties which can delay, interrupt, or obscure communication. Really? On the telephone? Like, I'm pretty sure it's landline to landline, ma'am. I don't know what technical difficulties. I mean, I guess it could be a voice over IP and you might have issues. I don't know. And allows the respondent to interact directly, clearly, timely, preserving the court's invaluable time.
You got that, Miss Jackson? She's thinking about you and your time.
Number 7, the respondent's transport to the court and proper inclusion in the courtroom serves the legal interest of due process, increasing her ability to be rightfully understood as a serious and committed party in this case in respect for the court, ensuring fairness and justice under her extraordinary circumstances, the Florida and United States constitutions. Ma'am, they're not extraordinary. You put your boyfriend in a suitcase and you refuse to let him out. He called your name again and again and again. Were you worried then about due process, fairness, justice, the Florida or the United States Constitution?
I think not, Miss Boone.
Wherefore, pro se respondent Sarah K. Boone respectfully requests from this honorable court to enter an order for transport to fully have the ability to represent herself in this family law trial, and after her continued determination, eagerness, hard-fought effort to do so, for a hopeful legal and just outcome for over 5 years. Respectfully submitted this 8th day of August 2025. Pro se respondent. So this was electronically submitted, so there's no envelope, but I'm wondering, today's the 20th, where the heck has this been since the 8th? And that makes me feel like if it's DOC related, she definitely is not getting Brian's exhibits in time. Oh, but it doesn't stop there. She's got a motion for contempt. And if you're thinking it's the motion for contempt from failure to pay, you'd be wrong. It is not that motion. This is a motion for contempt and to compel petitioner to submit visitation applications
immediately.
Comes now, pro se respondent Sarah K. Boone submits her motion for contempt and to compel petitioner to submit visitation applications immediately after raising her concerns to the judge as stated in the order after case management conference on May 29th, 2025. So let's debunk that part because there was no order. Therefore, her motion for contempt is not valid. This is from the order from case management. 5. Respondent also raised concern about petitioner not preparing an application required by the Department of Correction so that the minor child could visit her. There was no pending motion before the court on this issue, but petitioner did provide information to the court on his efforts in submitting the requested application, and he advised the court that he would attempt to follow up on the status of the application. So there was no committal made, there was no order given. So he can't be in contempt. Clearly an attempt, he said he would attempt. Doesn't mean he would do it. So this is a lie. It was not in an order. We'll go on. So really, this should have just been a motion to compel. I guess the judge can deny in part and grant in part if she is so inclined, but it really is going to depend on the parenting plan at this point that the judge comes up with, because this could all be moot if the judge doesn't order him to visit. But I guess you need it even for video visits. So anyway, but you guys know what I'm saying, right? The respondent has repeatedly been requesting from the petitioner to submit the visitation forms since her transfer to Department of Corrections in January 2025 without completion to date. It's redundant. We know it's without completion. That's why you're filing this motion, honey. And after innumerable reasons, excuses why he has not or cannot for ongoing 8 months. This is the reason respondent made the emphatic decision. So she's totally using emphatic incorrectly here. Emphatic is not a decision. Emphatic is, well, let's just look. Hold on. I'm going to tell you the exact definition. Because I'm like, an emphatic decision? Maybe an emphatic declaration, showing or giving emphasis. So how are you showing or giving a decision emphasis? Like expressing something forcibly and clearly, not a decision. Maybe made an emphatic outburst. But even then I would say passionate, because emphatic sounds bossy, you know? Anyway, to verbally motion the court in the conference to make aware his ongoing untruths and difficulties in withholding her son from visiting and for no valid reason, S in parentheses, petitioner's counsel even volunteered to submit these applications on his client's behalf after being sanctioned for non-compliance of scheduling the required in-person meeting of the parties for the pre-trial conference. So now we're still digging up dirt. We already discussed that. He was not sanctioned. He was reprimanded. There was no sanction for non-compliance. They were just told next time, seek leave from the court. Also stated in the order filed May 30th, where to date, and after the court giving a 2-week due date, no applications have been received per the DOC classifications department's most recent update to the respondent on August 7th, 2025. The 2-week due date, incorrect. We just looked at it. There said nothing about it. It said he would attempt. The judge didn't give an order, didn't say she'll follow up. The judge didn't give any sort of time on that, right? No pending motion. Petitioner did provide information. So to me, that implies that while there was no motion, because it got brought up, the petitioner volunteered this information and advised he would attempt to. But there is nothing about it is hereby ordered he do it in 2 weeks. And this is the whole case management order, so it would have been included in here. I don't, but she can misquote this, but she forgot to turn in she was given 30 days to prepare her pretrial statement, May 29th, and she didn't turn it in until July 28th. So, but she doesn't mention that in any of the motions while she's busy tattling on people. I don't get it. You guys let me know what you think. Other than there's something wrong with Sarah. And again, she says the counsel volunteered to submit it. We have to take her at her word. That's not in the judge's order either. Respondent has sent multiple tablet messages.
If that ain't the understatement of the year, ma'am.
And mailed messages to the petitioner requesting status, even completed the applications for both and mailed with instructions. They only needed to sign and add work information.
Oh, really? Your son has a job now? Because Peter didn't put any work information on his application and he got approved the second time.
What happened, Sarah? You were just dying. So I feel like this is all like a passive-aggressive loop to say, yeah, he doesn't want to tell me his job. That's why he's not doing it. And therefore, this motion for contempt. But it's not true that he has to put a job on there. I mean, it's just not. In her letter, she also explained again to him the importance of her desperately trying to still see her son. And during one of his 100 days of summer before starting school, and after over five years of waiting prior in a simple video visit. So that is just a blatant lie. 5 years of waiting, that we've seen that. You and I have gone over that. Multiple video visits with the two of them. Did the son attend all of the scheduled ones? No. Were there scheduled ones? Yes. So unfortunately, I don't think that's going to be entered into evidence, but
nonetheless,
it's in the past. Like, that was when you were in county, ma'am. You're now in the penitentiary. And we don't know if the judge has agreed that you should get visits. Petitioner has not responded to any of her messages or letter.
Can't take a hint that maybe stop asking?
And upon answering a call from her from no responses, that I don't know what she means from no responses. Like, does she mean like before she said anything, which wouldn't be a response? Like, before, or is she saying the call is that she called because there was no responses from the letter or the messages? I don't see Brian sitting down to write you a letter, Sarah. I'm going to be honest. And clearly, after all these years where he has not responded to one tablet message, you have a, what is that? You're just doing the same thing over and over again, expecting something different. Like, ma'am. He swears and tells her he'll check on it, then disconnects. This is the same reason he gave the court. Still no application submitted by either. No, the reason he gave the court is he'll attempt to look into it. These false statements made by the petitioner under oath and his counsel, in addition to their deliberate continued chaos, in quotes, and non-compliance, is contempt. So it's not contempt because we can't prove he made a false statement. He said he would check on it. He would attempt to check on it, Sarah. So you don't know if he's attempted to check on it or not. How could you know that?
Ma'am.
She's still mad about that chaos. And what false statement did his counsel make? That he would help him out with the application? He still would need Brian's signature. They'd have to be in the same place at the same time. I guess they could do e-sign. Shout out to CLR. Bruce Rivers. Yeah, it's just a nuisance. The judge will see it for what it is. Wherefore, pro se respondent Sarah K. Boone respectfully requests from the court 2, 1, compel petitioner and or his counsel to submit the visitation forms immediately for her son and himself. Remembering the process takes already a minimum of 30 days to process. So, and now we've taken a leap, right? Because it's not just submitting the applications. It's assuming that Brian is going to go. And I don't think he's going to do it voluntarily, because we know Brian has to sit with him in the visitation room while he's visiting with his mother. The judge is going to have to order that. I mean, unless she would agree to video visits, but her demand was for 1 to 2 times a month in person. You haven't been granted that, Sarah, so nobody's in contempt. Sanction both for perjury. Again, no one perjured themselves. He said he would attempt to look into it. Ignoring and disrespecting the court and respondent.
The Judge Jackson is probably like, girl, don't loop me into this. I don't feel disrespected.
Causing emotional distress to the minor child in his continued attempts to see his mother. Really? And violating the respondent's parental rights in avidly seeking and growing her parental relationship with her son. What about when you were at the bar till 2 o'clock in the morning and men were stumbling into your home looking for you? Were you then avidly seeking and growing your parental relationship with your son? Or is it now that you're contained that you are seeking this? Had you not murdered George, would you be seeking this? It just seems awfully convenient. Number 3, order such relief or disciplinary action as this court deems just and proper. What, like you want him put in jail? What kind of disciplinary action? You want his attorney disbarred? Ma'am, what are you saying? Respectfully submitted on this 8th day of August, 2025, Sarah K. Boone, pro se respondent. And then get this. She rang the clue phone, ring, ring, because she actually filed cross notice of hearing. Now, It's for the motion that we just read. It's not for her contempt motion for failure to pay, which is going to be considered moot, right? It will be denied, dismissed, disregarded because there's no cross notice for it. But this one, which has absolutely no teeth, she's filed for the cross notice of a hearing. Brian can't be held in contempt because there was no order. So what is the contempt? He told the judge he would attempt looking into it. If he gets on the stand and swears under penalty of perjury, I attempted to. I couldn't fit it in my schedule. I am a single dad and my son, it's summer. I'm trying to keep him occupied.
What are you going to do?
So, respondent's motion for contempt. So please take notice. Pro se respondent Sarah K. Boone will bring for hearing respondent's motion for contempt and to compel petitioner to submit visitation applications immediately before the Honorable Judge LaShonda K. Jackson in the trial for the aforementioned family law matter on Monday, August 25th at 1 p.m. And then it's in the court. I just take the address out because YouTube gets wonky about addresses. The hearing for this motion is estimated to last approximately 15 minutes. So she finally figured out how to cite the time that she needed. Respectfully submitted on the 8th day of August. I thought you wanted your jammies on because you were going to lay down. What happened? Yeah. Can I have a kiss? Thank you. What do you guys think? I mean, I should not be astounded anymore. Balls of a burglar. I really shouldn't. She knows no bounds. She has no shame. But we'll see. Like I said, I'll keep an eye on the docket. Oh, I'm doing research. So, you guys know Danny's channel, right? Danielle Chavon. She did an update on Judge Jackson. And it turns out, I recommend you go over there and see it. But I'm going to do a little more research because I kind of want like actual details, but high level, guys. Judge Jackson, I told you before she was in foster care, right? I didn't know exactly why her mother murdered her father, which is crazy. And her mother had her at 19, and it was her 4th child. Check out Danielle's video on that. I feel like that helps her identify more with the son, even though it was Sarah's boyfriend. It was like a playmate of her son's, right? And her mom has shown no contrition, or his mom, sorry, the son's mom has shown no contrition. How does that impact him? You know? And then all of her shenanigans are public. So it's fodder for everybody. I don't know, it just gives it it's like even deeper than what I thought before, but I'll get more details in like, was she present when it happened? What were the circumstances? She's definitely pulled herself up by the bootstraps to become a judge, right? Like she beat all the odds. Oh, and her nickname is Bullets. The judge's nickname is Bullets. I found that in my research because the way she was firing off questions, I think one of her professors named her Bullets. But I'll get into that in another video. I'm going to go attend to the dwarfs in my castle. I am excited to hear what you have to say. I am just like, are you gobsmacked or are you beyond? Like, nothing she does can surprise you. Because this is another balls of a burglar move, in my opinion. We'll see. I mean, no one can ever say she didn't fight for herself, even though she claims to be a victim always. She's also a fighter, even if she's shooting blanks. I'll talk to you guys later. Toodles! See you in the comments.